You each will have 15 minutes, and the appellant may reserve up to 5.
Thank you, Your Honor.
Just let me know if you just save some time.
Thank you very much. Good morning. May it please the court, I'm Conrad Olson on behalf of John D. Kuhar, the appellant in this matter. I would like to reserve 5 minutes for rebuttal.
Thank you.
Interestingly enough, Your Honors, I suspect I'll need neither the 10 minutes allotted to me nor the 5 minutes for rebuttal. This is a fairly straightforward case. I've had an opportunity to put my thoughts together here, and what I would like to point out to the court are there are several what I consider key components of this case. I'm going to address all 3 of the issues that I've presented to the court, but I'm not going to present them to the court in order that they were written in my brief. I've decided on a different tack here.
Oh, you're testing us then.
Not necessarily.
Okay.
And quite frankly, if I am testing you, I'm sure the court has the skill to pass that test. But I would like to start with what is presented in the brief as a second issue before the court. That's the issue wherein I suggest to the court that the prosecutor improperly questioned and badgered the appellant, Mr. Kuhar, in this matter regarding the issue of restitution in this case. And I know that the standard is plain error here, or at least I believe the standard to be plain error. Reason for that is that during this line of questioning, there was no objection raised at the trial court. However, it is interesting to note that the prosecutor inquires of Mr. Kuhar whether in fact he has paid restitution at the trial, obviously. And I think timelines are important with respect to this issue as well. Just very briefly, I'll go over the timeline with the court, and I'm sure that you all already are fully cognizant of this. This is a case in which Mr. Wattenbarker, I hope I pronounced his name correctly, has searched the internet. He's looking for a specific transmission for his 1977 Chevrolet El Camino. Mr. Wattenberger testifies that, gee, I'm really having a great deal of trouble finding one of these. So I'm looking all over the place. I look on the internet and I find a place called Medina Motorsports, and it appears that they have one of these transmissions. This occurs in April of 2014. I believe that the date is April 3rd, 2014. So Mr. Wattenbacher picks up the phone and he calls Medina Motorsports. The phone is answered. He says that the gentleman identifies himself as Mr. Kuhar, John Kuhar, the owner of Medina Motorsports. So this is in April of 2014. After reaching an agreement, Mr. Wattenbacher sends a check to Mr. Kuhar. This is uncontroverted. A $1,600 check is presented, and that check is negotiated by Mr. Kuhar. Mr. Kuhar testifies to that. Detective Gross testifies that she verified that the check was cashed and deposited in the account. And Mr. Wattenbarker also testifies, I sent him a check. He identifies the exhibit. It's admitted without objection at the end of the trial. Now, I know I've taken a long time circling the wagon here because I started out talking to you about, hey, I'm going to talk to you about the timeline of this case, because I think the timeline is very important. This happens in early April of 2014. Mr. Kuhar subsequently testifies that, Mr. Wattenbacher subsequently testifies that, look, I'm trying to follow up on this and get this done as quickly as possible. So he calls back the next week and says, hey, where are you at with the transmission? To which Mr. Kuhar responds, I'm sick. He does this 3 consecutive weeks. And each time when Mr. Kuhar speaks with him, he testifies that he tells him he's sick. At this point in time, it appears that Mr. Wattenbarker is thinking, oh, what's going on here? Am I in trouble here? he testifies that he searches the internet and he finds some complaints against Mr. Kuhar. So at that point, he's concerned, but he continues to call. Now we're talking late April 2014. Early May 2014, Mr. Wattenbacher testified that, what am I going to do? Call the Medina police. Let them know we got a problem here. Well, he calls and he speaks apparently with Detective Gross. Detective Gross goes out. Actually, he doesn't necessarily testify that he spoke with Detective Gross. He talked with the Medina police. When Detective Gross testifies, she says that the lieutenant asks her to go out and do an investigation. She then goes out to Medina Motorsports and speaks with Mr. Kuhar. Now, her testimony is a little unclear, as is the testimony of Mr. Wattenbacher as to when this actually happened. There appears to be a little bit of a dispute here, but when you look at the testimony, you'll find that the detective says, I went out in July of 2014. So in July of 2014, there's no doubt that Mr. Wattenbacher does not have his transmission and he doesn't have his $1,600. But when she goes out to speak with, that's Detective Gross, to Mr. Kuhar, Mr. Kuhar says, hey, look, I had to go find a transmission, I had to get parts, and I've just been busy, and the guy has been pestering me. So she advises him, you need to talk to this fellow. You need to call Mr. Wattenbacher. So Mr. Wattenbacher testifies that Mr. Kuhar does in fact call, and he leaves a message for it. He also testifies, hey, I'm kind of surprised by this. But he calls him back. And when he calls him back, he goes, look, I had to take this is Wattenbacher. He says, I had to take another direction. I'm getting my transmission elsewhere. I need you to give me my money back. To which Mr. Kuhar testifies that he says, hey, look, I don't have your money. I have the transmission and I have the parts. But if that's what you're doing, that's fine. I'll send you your money back. But I have to sell the parts and I have to return things to my vendor to get my money back so that I can send you a check. Mr. Wattenbacher says, that's fine. And just keep in mind, this is in July of 2014. Well, eventually, Detective Gross speaks with Mr. Wattenbacher, and again, the timetable is somewhat fuzzy, but this occurs in either August or September of 2014. At that point, he tells her, look, communications have broke down, haven't been able to hook up with this guy, don't have my money back, don't have my transmission. So ultimately, what happens is that the detective goes out and arrests Mr. Kuhar. He's actually indicted on 2 counts of theft, as I'm sure the court is aware. That indictment comes out and is docketed by the trial court on September 24th, 2014. Well, now we're back to trial. Mr. Kuhar is arraigned in October of 2014. And at that arraignment, the court puts forth an order with respect to his bond. One of the conditions of his bond, no contact with the defendant, or excuse me, with the victim in this case. So when the prosecutor is questioning Mr. Kuhar about restitution, Mr. Kuhar attempts to interject in his answer, look, I haven't paid him. I got the money, but I haven't paid him because you put out an order that I can't talk to him. I can have no contact. And it's interesting because at this point the prosecutor appears to indicate on the record, I don't know what you're talking about. I did not order that you have no contact with him. I don't know anything about that. But interestingly enough, it's an order of the court, and I would presume that the prosecutor is cognizant of what's in the file and was likely sitting right in the courtroom when the judge articulated that order. This judge is very specific about those types of orders.
Did your client have legal counsel at the time of his arraignment?
I believe counsel was appointed after the arraignment. And in fact, at the trial, as the court I'm sure is aware, he had 2 attorneys sitting at the table with him.
And so your position, I think, if I follow in the brief, is that once he was represented by counsel, he could not have paid the victim through his attorney. Is that the position that you're taking?
It is, Your Honor, and the reason I take that position is because, generally speaking, this judge is very specific. You know, he'll go so far as to say, no contact means no face-to-face contact, no telephone contact, no email contact, no contact by mail or Pony Express, no smoke signals, no contact through a third person. And obviously, Mr. Kuhar, you know, without trying to get into the guy's head, I would think that he would believe that means his attorney. Now, I'm not going to
believe that his attorney would think that he could not, in order to resolve the matter, he could not pay.
Actually, Your Honor, that question is answered in Mr. Kuhar's testimony. In his testimony, when this back and forth is occurring, he actually says to the prosecutor, "You told me I can't have any contact with the victim," to which the prosecutor responds, "I didn't tell you that."
I read that.
And the prosecutor, then Mr. Kuhar responds, well, the court did and my attorney told me I couldn't have any contact with this guy. Now, I'm not going to second guess the...
And counsel, I want you to answer Judge Moore's question, but you are in your rebuttal time, so.
I think you've answered it
Okay.
to my satisfaction. Thank you.
All right, well, I'll wrap this up very briefly then, because what I'm doing is I'm going to try to show the court there's a culmination in this case. In the instance where the prosecutor is inquiring about restitution, you know, it's a long belabored process of inquiry by the prosecutor, which I'm not going to call it badgering, but it certainly went beyond the bounds of, hey, did you pay? No, move on. Again, I admit there was no objection at that point. The second area that the prosecutor inquires of, which I find to be more troubling than the first area, is that at some point in questioning, the prosecutor is inquiring of Mr. Kuhar, and he turns around and he said, "Do you recognize these people in the back of the courtroom?" Quite frankly, defense counsel did object to this whole line of questioning. What the prosecutor is, in my opinion, attempting to do is he's attempting to show conformity by prior acts without even introducing any testimony about prior acts. He goes so far as to ask, "Do you know these people? These people are customers. You worked on their vehicle for 7 or 8 years. Did you give them their parts back? Isn't it true that the police had to come and retrieve parts when they arrested you?" You know, it appears pretty obvious to me that the prosecutor is trying to assassinate the character of Mr. Kuhar and to introduce improper character testimony to show conformity with the present act. And equally surprising is that the judge overruled the objection. I mean, these folks never testified. There was no evidence of any other charges, of any convictions. There was nothing. And what's interesting to me is that the prosecutor is aware of who's in the back of the courtroom and how they're connected to Mr. Kuhar, but at the same time pleads ignorance to knowing that there's a no contact order as part of his very own case. And the third thing that I want to touch on very briefly is during the inquiry cross-examination of Mr. Kuhar, the state, the prosecutor, is asking him about what he did in this case. Mr. Kuhar has testified, "Hey, look, I had to go to swap meet, find a transmission, and I had to order parts." The prosecutor said, "You didn't do anything." He said, "Well, yeah, I did something. I went out and I procured the parts, I procured the transmission." To which the prosecutor says, "Hey, show me a picture of the transmission. Hey, show me a receipt that you bought the transmission. Hey, show me a receipt that you bought the parts to rejuvenate that transmission." Seems to me that at this point, where we're going is we're asking the defendant to prove that he's not guilty, totally reversing the presumption in any criminal case, the presumption of innocence. The state is required to prove beyond reasonable doubt defendant isn't required to prove anything. So when the prosecutor's asking these questions, I would submit to you that defense counsel asked the detective, hey, did you ask for receipts? Hey, did you ask to look at the transmission? Did you ask to look at parts? And conveniently, the detective replies, I wouldn't know. He could show me any receipt, it wouldn't mean anything to me. He could show me any part, it wouldn't mean anything to me. Perhaps the detective should have done just a bit more homework before going out to interview and arrest Mr. Kuhar. Thank you. How much time do I have?
10 seconds.
Sorry. Thank you.
Sorry.
Good morning, Your Honors. May it please the Court, my name is Matthew Kern on behalf of Dean Holman, Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. This may be our one point of agreement on this case, and I guess I would agree with Mr. Olson that this is a pretty straightforward case. I'll start out of order with the assignments of error as well, and move first to the sufficiency issue, which I think this Court would have to answer first before it address the other two anyways. And on that, I would note that the primary point of contention in this case is whether this case is like State v. Chait, a case out of Medina County, which also is a theft case involving what this Court has sometimes referred to as a contract dispute. This is not a contract dispute, this is a crime. At the time of the formation of the supposed agreement between Mr. Kuhar and Mr. Wattenbarker from New York, it's evident from the facts and the other circumstantial evidence adduced at trial that Mr. Kuhar simply had no intention to perform the work or to repay the money when requested.
What specifically is that evidence that you point to demonstrate that?
Well, we'll start with Mr. Kuhar's admission on cross-examination in this case that he did not do any work, quote, at all, end quote. Despite the, and I agree, the timeline is important, and we should refer to it. April 3rd, 2014, Mr. Wattenbarker calls Mr. Kuhar and then sends him a check on that day for $1,600. He calls a week later. Defendant then says, I'm sick, I can't do any work. There's no testimony when Mr. Kuhar actually testifies at trial that he was actually sick. Instead, he repeatedly refers to Mr. Wattenbarker's phone calls as annoying and says that he's a pest. I'm sorry, I didn't know that the man who sent you $1,600 to do work was somehow annoying you for following up and saying, hey, how's it going? Is that 1 minute phone call really that much of an annoyance to you? No, that's indicative of a person who just wants the money and doesn't want to do anything. Then a week later, a second phone call, the same issue. Again, Mr. Kuhar says he's sick, can't do any work. The next week, so now we're at least into the week of April 24th, almost a full month after $1,600 has been sent via check to Mr. Kuhar, Mr. Wattenbarker calls again and follows up and says, hey, I know you've been sick the last couple of weeks. Wink. How's the work going now? Any progress? Mr. Kuhar says, no, I can't seem to shake it. I'm still sick. Oh, and a tractor trailer somehow sunk into the yard outside my business. I haven't been able to do anything. This, despite Mr. Kuhar's later testimony, that all the while he claims he was trying to do the work and was looking for this transmission and found it at a swap meet. That testimony is...
How long did it take for him to find it at the swap meet?
Well, first of all, from the state's perspective, we don't believe he ever did. Secondly, Mr. Kuhar isn't specific about when that happened. He can't be. He says he doesn't remember when. He doesn't have the name of a person who he bought it from. He doesn't have a receipt documenting that transaction. He doesn't have any inventory logs demonstrating that it was in his possession at his business. It never happened. That's why Mr. Kuhar's testimony was simply incredible. The other facts and circumstances attendant to this case, the repeated denials of any obligation to continue to perform work, his repeated insistence that he did something but has no proof of it, and let me address this point about turning the presumption on itself and requiring the defendant to present proof of his innocence. When the defendant testifies in a case, when he undertakes the non-mandatory issue and places himself as a witness in the case, he puts his credibility at issue in the case. He puts his version of the facts at issue in this case. It is not improper for the state or whoever the opposing party is, in any case, civil or criminal, to attack the credibility, and if you want to call it a character attack, that's what we're doing when we attack credibility, right? You attack someone's credibility, you're attacking their character. When a person testifies, cross-examination permits you to examine bias, veracity, credibility, all of those various things. The rules specifically permit cross-examination on those points, because how are we supposed to test whether Mr. Kuhar's version of events is actually true? The sufficiency challenge and the other issues raised in the brief all assume, without any basis, that Mr. Kuhar's version is the version the court should adopt. There's no basis for that. Mr. Kuhar's version was roundly impeached by the state. There is no corroborating evidence of that fact.
Was there anything in the record when Mr. Kuhar was interviewed by the detective that he told the detective that he had been sick and that's the reason why work had not been done?
I don't recall that specifically from the detective's testimony. It's not in his testimony. He doesn't say, when the detective came to see me in July, I told her I was sick and that's why. The detective goes to visit him and essentially says, hey, we got this complaint from this guy in New York. I don't really want to get into it that much. It sounds like it might be a contract thing. I don't want to get into it. Can you handle this, please? Can you talk to him, figure out something, and essentially make this go away? And Mr. Kuhar says, oh yeah, we'll take care of it. I'll call him. And actually, from the state's perspective, that's further evidence of his intent, because when he calls Mr. Wattenbarger and has that conversation about repaying the money, Wattenbarger says, hey, I just want my money back. Look, the relationship here is beyond repair. I don't trust you. Just give me my money back.
Was there some testimony or evidence that the defendant was working on other jobs and his position was he was looking for transmission or something of that nature?
So there are two.
As opposed to being sick.
Yes and no. There is some testimony in the record that he was doing these other jobs and that he was annoyed with Mr. Wattenbarger because other jobs came first. Mr. Kuhar did try to testify to that fact, which then, A, opens the door for the cross-examination of, well, what are these other projects that you're talking about? And Mr. Kuhar also says, I think it's transcript page 87, as regards to the first assignment of error, that, well, my other customers are fine with this. And so that invites cross-examination by the state, which happens after that statement by Mr. Kuhar about, well, let's talk about those other customers. 99% of your other customers are fine with being patient. Well, let's talk about that. One of your customers working on a Triumph, you've had the car for 7 or 8 years? Yeah. And how much money have they paid you? Over $60,000? Well, isn't it over $80,000? Oh, yes, I think it is over $80,000. And have you given them the car back after 8 years of work and $80,000 of money that they've given you? Oh, no, I'm still working on it. Mr. Kuhar raised that issue by pointing to the other customers being patient with him and inviting cross-examination on that point. The other thing that I would mention there is even if the key issue here is Mr. Kuhar's intent. So going back to facts and circumstances, being critical to evaluating what is a person's intent, all of the facts and circumstances, context is king. And in this case, context is not just the specific formation on, we'll call it April 3rd, or a few days before when he and Mr. Wattenbarger had that phone conversation and Mr. Wattenbarger then sends the check. Well, what is his course of practice? That is important for facts and circumstances too. That context helps you establish what a person intends to do, motive and intent. So even if you consider this 404B evidence, it is admissible 404B evidence. Our contention is we didn't necessarily offer it for the truth of the matter. It was much more for the impeachment purpose of Mr. Kuhar. So it's not 404B evidence. It's more 608B, specific instances of conduct evidence, to impeach Mr. Kuhar. But circling back to the sufficiency issue, the difference between this case and Chait is that in Chait, this court found that the defendant there did about 70% of the drywall work, substantial framing work for the garage, and other substantial progress that was actually, there was an agreement, money was paid, and the defendant actually did something. The fact that it made things worse, I guess the court found was beyond the point. Regardless, in that case, the defendant did something. In this case, Mr. Kuhar gives you the clearest evidence of all. If we believe one thing that he said while on the witness stand, it's this. When asked, did you do any work? And he says, no. And the prosecutor follows up, you didn't do anything? And he goes, no, I didn't do anything. And his quote is, at all. He did no work. So I guess he later clarified that his supposed work of finding the transmission and acquiring parts that really he admits in his testimony he already had in his inventory before taking on this work, and then supposedly selling the transmission conveniently so that they didn't find the transmission he had previously purchased. He admits, no, I didn't do anything. I didn't do any work on this project, quote, at all, end quote.
Well, he says he had to sell it to get the money to pay it back.
He also says he bought it at a swap meet, but that does not make, if these transmissions are so rare that Mr. Wattenbarker would have to call from New York to Medina because he's looking for it on eBay, you would not acquire one of these without a receipt for an insubstantial amount of money at a swap meet. It doesn't make sense.
So he didn't have a receipt.
He did not, he admitted he did not have any receipts for the purchase, he did not have any receipts for the supposed sale, he didn't have any inventory log showing that it was ever in his possession, he never had a photograph of this transmission that he acquired for this project. There's no evidence in this case that Mr. Kuhar, aside from his bare assertion when he testified, incredibly testified, there is no evidence in this case that he ever actually acquired the transmission and then later sold it. There's no evidence of that beyond his word, which was roundly impeached. So, in the state's case, construing the evidence in the light most favorable to the state, as the court must in a sufficiency challenge, making all reasonable inferences, Mr. Kuhar never did any work. He never bought the transmission, he never acquired parts, he held on to $1,600 he was not entitled to, and refused to repay. Now, that brings us back to...
Well, you say he refused to repay. He said, I can't repay you until I sell the transmission.
Right, and if we're construing the evidence in the light most favorable to the state, that evidence indicates that he never acquired the transmission, therefore he never spent any of the $1,600. It was available for him to repay. He lied. Construing the evidence in the light most favorable to the state of Ohio, there is sufficient evidence that Mr. Kuhar knowingly acquired money with no obligation, with no intent at the time he acquired it to perform the work, because he didn't over a 7 or 8 month period, despite repeated follow-up calls by the customer, or even after being contacted by police in July, some 3 or 4 months before he was eventually indicted. In that 7 months, he did nothing. Absolutely nothing. This case is like a recent Summit County case that I know I haven't done the supplemental authority, but it just came out within the last month or so. This case is a lot like a recent Summit County case where a roofing contractor shows up to an elderly woman's home and says, you have a problem on the roof, I'll fix it for you. And he sends her a before photo from his cell phone, but refuses to send one after. And a later contractor goes up and says, I've looked at the roof, and when I went up there, and the before photo that the defendant sent her before he supposedly did the work, he didn't do anything. And this court upheld that conviction. I understand it was
I was going to say there was a little dissent there.
Yeah, I understand that, Your Honor. And the point I'd make there is...
It's a different case.
This case is actually even better than that one, because this case he did nothing. He took money with no intention of performing any work and did in fact fail to perform any work.
What position do you take on the question of whether he could have made restitution after he was indicted?
So this issue is really framed in the context of how the appellant presents that assignment of error. We're talking about the second assignment of error there. The captioned assignment of error says that the trial court erred in refusing to take some kind of action, but there was no objection at trial. This case is like an older 9th District Medina County case, State versus Muhammad, where the defendant claimed that the court erred in failing to grant a mistrial, but it failed to request a mistrial. It just said, oh, this was so bad the court should have just sua sponte done this. And this court said, no, when you want the trial court to take action, you have to ask the trial court to take action. There's no objection here. Beyond forfeiting all the plain error from an evidentiary standpoint, the caption assignment of error says the trial court failed to take action it was never requested to do. For that reason, this court should overrule that assignment of error. On its merits, however, what I'll say is Mr. Kuhar specifically raised this issue by saying that I was unable to pay it back the money. Now, the key issue in this case is taking money with either no intent to perform the work and or no intention to repay. So the repayment issue is a critical issue in this case. When the prosecutor asked questions about the restitution, he was asking specifically prior to indictment. This is July, when Detective Gross goes to the motorsports company and asks, hey, just figure this out, give him back his money. The repayment question, he says, well, I can't, after October when I'm indicted, I can't do follow through. You told me I couldn't do that. The prosecutor isn't badgering him, he isn't mocking him, he's clarifying this. I didn't tell you anything. Now, Mr.
Counsel, you're out.
If I may briefly conclude, Your Honor. Counsel's insinuation is that the state knew that and was deliberately asking a question he already knew the answer to. That's somewhat inaccurate. The issue isn't, was the prosecutor aware of the no contact order in the file? The prosecutor is clarifying, I'm not the one who told you that. That's all that happened in this cross-examination. Mr. Kuhar advanced an issue, and the prosecutor clarified. That's not improper. So there's no prosecutorial misconduct, and more specifically, it was never a request to the trial court to take any corrective action. For all of these reasons, I respectfully ask the court to affirm.
We need to wrap it up.
Thank you very much.
I let the prosecutor go over like 30 seconds, so come on in.
Very briefly, just several things I'd like to point out.
Well,
Number
you
one-
only have about 40 seconds.
Number one, this is clearly a contract action. There was an offer and acceptance over the telephone, a check was sent. With respect to how long it took Mr. Kuhar to obtain the transmission on page 72 of the transcript, it took him 3 weeks to obtain the transmission. As far as restitution goes, or repaying the $1,600 to Mr. Wattenbarker, Mr. Kuhar testified that when Detective Gross comes out in July, he has all the stuff. He says, look, I'm going to call the guy. We calls Mr. Wattenbarker. Eventually they connect. Mr. Wattenbarker refuses to take the stuff. So in July, he has the stuff. He has to sell it in order to repay the money. Thank you.
Thank you. Thank you, counsel. Thank you both. We'll take the matter under advisement and issue a written opinion that will be sent to both sides and we'll release on the website. Thank you so much.